Mr. Brown is now present. He represents, I believe, Ms. Jacoby Radke. Is that correct, Mr. Brown?
It is.
All right. She is present with us today. I still do not see Mr. Matisse on behalf of Douglas Brown, and Douglas Brown does not appear to be with us as well.
Your Honor, I'm
Yes.
so sorry to interrupt. I have not spoken with Mr. Larry Brown at all, and I had no idea he was going to be representing me today.
All right. If something comes up where you need to speak with him during the hearing, we can put you in a breakout room so that you can do that. And I'm sure that he will want to speak with you after the hearing as well. This is one of the first, and it's a preliminary hearing. So it's not unusual because of the time limitations for that to occur. So I'm sure that he'll speak with you afterwards. Anything that you want to do right away, Mr. Brown, or can we proceed without that?
We can proceed without that. If she needs to speak with me in a breakout, I can do that as well.
Right.
I don't think I would need very long.
All right. Thank you. All right. It does appear that everyone has received proper notice. Court file has notices of today's hearing going out to, including all the parties that are present, including Douglas Brown, who is from Fair Oaks, California. That notice went out on March the 30th. Nothing has been returned to the court that indicates that he did not receive that. It also went out to his attorney, Gabriel Matisse, out of Harbor Springs. So I'm prepared to proceed today on preliminary examination, or excuse me, preliminary hearing. Just for everybody's information, a preliminary hearing is one of the first hearings. It's simply a determination of making sure that everybody understands what their rights are, make sure that the attorneys have been appointed, and that everybody is starting the process appropriately, and making sure that we know what whether or not the petition will be authorized today. Ms. Radke and Mr. Tingley, I apologize for the mispronunciation. You have the following rights: the right to an assistance of an attorney, the right to have a trial by a judge or by a jury, the right to admit or deny the allegations, and the right to be heard on whether or not the children should be placed with you or with some other member of the family, and then a determination of whether or not to authorize the petition. As to all of those things, do all of you, Mom and Dad, do you understand the rights that I've just explained to you?
Yes, Your Honor.
Yes, Your Honor, and I would love the opportunity to make a statement when it is convenient for the court.
Your Honor, I would like to speak with her before she makes a statement.
I don't need to speak with Mr. Brown.
All right.
I would like to speak for myself.
All right. I certainly understand your desire to do those things. The court has to take things in order of how they proceed. Right now, whether you make a statement or not isn't going to change the legal stance of the case, because there's been no evidence produced yet. You are presumed to not have any responsibility until there is evidence of that. This is a preliminary determination at this point. So in a moment, I'll hear what you want to say. The next step is to determine whether or not the petition needs to be authorized or should be authorized, so that the court can take a preliminary jurisdiction in the matter. As to that, Mr. Delaney, as to Mr. Tingley, what is your pleasure?
I've spoken with Mr. Tingley about this case. I don't have a clear picture from the petition what the allegations are. As to Mr. Tingley, it appears to be a housing situation. So once I get more information, so I think I will request a preliminary exam so I have a better understanding of this case. And if the department's not ready, I explained to my client that may be an adjournment, but once I had that information, I can make an evaluation. So I am requesting a prelim at this time.
And Mr. Brown, as to a determination of whether to authorize the petition, what is your pleasure?
Again, Your Honor, I have not had an opportunity to speak to Ms. Radke.
All right. We'll, in order to protect all of your client's rights, we'll indicate that a preliminary hearing is requested at this time. Mr. Sommerfeld, are you ready to proceed on that today, or would you request an adjournment to have the appropriate witnesses available?
do have the author of the petition, Mr. Burke, here today. It doesn't sound like Mr. Brown, that he's, I think, like fully, if he hasn't met his client, I would not want to proceed under those circumstances. And if we're going to do.
Yeah, I don't feel comfortable, honestly, Your Honor, having this thrown at me last minute. I was completely to make a statement, and I am a firm believer in that my integrity and honesty is everything I have, and I honestly don't need his representation.
All right, Ms. Radke, what statement would you like to make to the court? Anything else other than what you just said?
I have so many things, but to summarize, there's been a lot of concentration on pointing fingers at me and claiming that I am mentally unstable. And I would just beg the court to recognize
Your Honor,
patterns.
I think.
No,
at this-
Mr. Brown,
Your Honor, I am appointed, so I would like to speak.
I did not appoint you. I didn't appoint you, Mr. Brown.
Okay, Ms. Radke, the court did, and there's a reason for that. And his concern is that you're going to say something unintentionally that may have the ability to damage your position in the future. And that is a well-supported fear. So if you're going to make statements about the facts of the case, I would caution you about doing that in this early part of the proceedings, because at this point, I haven't even begun to look at the facts of the case yet. We're simply in a procedural process at the moment. The facts of the case will come out over time. There'll be a time in the future for what's called the adjudication. That is a formal decision about whether or not certain things were done or weren't done. Today is not that day. Today, there might be some preliminary facts brought out, and you'll have a chance to argue about those or address those through your counsel. But today is not generally done where the defense or the persons who are accused lay out their side of the story. That's typically not what we're here for today. And I appreciate that that's difficult to wait, but that is the normal process. Is there something other than the facts of the case that you wish to tell me about?
Yes, Your Honor, just to please, I know I completely understand that that is the process, and I'm willing to do whatever it takes to get through this. But I would love the opportunity to be seen in a light that is just someone guilty of having a very human emotion.
Well, Your Honor, again, I don't.
No,
if she wants to,
Mr. Brown, please, I am not done. I have been silenced my entire life, and this is the most important time in my life, and I really need to make this statement. Okay? I don't even know why you're here.
Ms. Radke, he's here because the court told him to be here, and he has an important role to play. And whether or not you make a statement about what you think is important isn't what today is about. So I'm going to ask you to keep it really short, and I'm going to ask you not to involve the facts of the case. So go ahead.
I won't. I would love the opportunity to be able to see my children because I do believe that my track record of non-violent successful, goes against everything that is being said about me. So that is the only thing I would like the court to consider today, is to lighten up on the restrictions to my children, because they are the only people that I've ever loved.
Thank you. I appreciate that information. All right, Mr. Brown, as to proceeding today on facts which would allow the court to determine whether or not to authorize the petition, having not had a chance to speak with your client, do you believe that you can do that in a breakout room today, or do you need some additional time to do that?
Your Honor, just given the statements today, I would request an adjournment. It appears that she may want to represent herself, which is a whole different ballgame. So I would like an opportunity to kind of explain to her the process, the procedure, the risks of representing herself in a matter such as this.
All right, I do think it would be appropriate for you to explore that matter with her and help her understand the process in a little more detail so that she can make an informed decision about her right to represent herself or her need for an attorney in this process. So for those reasons, I am going to grant your request for an adjournment. Let me ask court staff whether or not we have any idea of when that could be rescheduled. April 28th. Looks like the next available date is April the 28th. What time would that be? We don't know yet. I'm not able to give you a time, so we'll have to set that out in a notice. I know that Ms. Radke is going to be asking and appropriately asking to have some contact with her children. Mr. Sommerfeld, or maybe MDHHS knows, what is the current status of ability of mom and or dad to have contact with the children?
Judge, I would ask Mr. Burke because I don't have an answer to that question.
Mr. Burke, can you answer that for me, please?
Yes. So per bond conditions, Ms. Radke is not able to have contact with Riley, Jordan, or River. There is a parenting time scheduled today with Kenneth, with Riley and Jordan.
All right. And the reason for the no contact, is that because there are pending criminal charges as well?
Yes. So there was a pending criminal charges of domestic violence and third-degree child abuse.
All right. And you have parenting time set up for Mr. Tingley. Is that an
Yes.
ongoing parenting time for Mr. Tingley?
I believe at the moment it is not. It was just kind of scheduled for today.
All right.
Your
What does
Honor.
the department? Hang on just a second. Let me finish my train of thought, and then I'll let you intervene as well. What is the thought going forward if we're going to have to adjourn this till April the 28th? We're looking at about a month from now. What would the department believe would be appropriate going forward for Mr. Tingley?
That's what I was going to speak on, Your Honor. You were just
Sorry, go ahead then.
No, you're fine. Moving forward after today's visit, I will be taking over for supervised visitation for him. In per policy, that is once a week for their ages. So we will help facilitate that moving forward.
All right, Mr. Delaney, any objection or any issues with that?
No, I've spoken to my client and I would just recommend he work with the department and with seeing the children. If there's anything that's not working for him, he can call me and we can file a motion to expand any parenting time.
All right, thank you. Any other issues that we need to address before I close the hearing today?
Your Honor, may I say one more thing, please?
Yes.
I'm so sorry. Thank you. If the visits are supervised and we are to proceed under the presumption that I am innocent until proven guilty, then I don't understand. I don't understand
Your
why
Honor,
I would not be allowed
I will
with
call her after court and
a
explain the
supervised
difference,
visitation with my
the
children.
difference between this case and the criminal case.
All right, thank you, Mr. Brown. Ms. Radke, and I can certainly appreciate your concern and your questioning of what's going on, because this is a complicated process. There are two things happening at the same time. One is the criminal case, and there is a criminal case order that forbids contact between you and the children right now. And this court can't overrule the criminal court. In addition to the criminal case, there is this part of the case, which is family and children oriented. And that outside of, if there are no contradicting criminal case orders, this court can enter orders as to the children as well. As of right now, I have heard no facts, so I've not made a decision one way or the other than as to what the normal process is to get to those decision points. So Mr. Brown, excuse me, can hopefully explain some of those things in a little more detail to you before we come back on April the 28th and begin that process of making decisions in this case. It's a slow process. I apologize for that ahead of time. But what we're trying to do is make sure that we make good decisions in the best interest of the children at all times and err on the side of being careful while we're doing that. And that may cause the parents some heartache, but in the law's view, it's better to have the parents having heartache than the kids getting hurt.
Absolutely.
So
I agree.
That's where we're at with that. So what we'll do today is I can't give you parenting time right now because of the criminal case status, and we will readdress that in the future if the criminal case status changes, and your attorney can certainly bring those issues to my attention in the future, just as Mr. Delaney can do that for Mr. Tingley as well. So having said all that, we will adjourn today so that Ms. Radke can discuss matters in detail with Mr. Brown, and I'll see everybody back here on April the 28th. The notice will indicate at what time, and we'll do that via Zoom as well. So thank you all very much. That's all for today.
All right, thank you.
Thank you, Your Honor.
State of Michigan versus Jacoby Radke, file 26-44429-FY.
For the record, Mike Rowland, behalf of the people.
Hi, Your Honor, Jacoby Radke, pro se.
All right, I do see Ms. Radke is with us. Ms. Radke, you indicated that you want to represent yourself. If at any time you change your mind, please let the court know. You'd be eligible for, or we would consider whether or not you're eligible for a court-appointed attorney, or you could hire your own attorney at any time that you wish. All right, this is a case that's set for a status review today. Mr. Rolla, is there any offer that's been made to this defendant?
There is, Judge. And again, it's a situation where I spoke personally to Ms. Radke yesterday after verifying she was not represented by counsel. There is a plea offer of count 2, domestic violence. That's a 93-day misdemeanor, as the court's well aware. Upon the court accepting her plea to that offense, the felony charge of child abuse would be, as set forth in count 1, would be dismissed.
Ms. Radke, you've heard what the prosecutor has said. Do you want to accept that offer, or do you want to not accept it?
Would I like to, could I respond, Your Honor, with an alternative?
I'm not going to have you guys negotiate in public. You can do that if you want to make a private phone call to the prosecutor's office, but the offer right now for today's purposes is what Mr. Rolla said it is. So you can say no to that and then try to negotiate with him in the future between yourselves if you'd like to do that. Is that what you want to do?
Would this automatically come with a deferred sentencing?
He didn't say that at this point, so I don't know.
Judge, she would qualify otherwise for 769 for a deferral. She doesn't have any priors. I believe that's what she's referring to.
I understand
Yes,
that.
thank you.
Is that part of the offer or not?
We can't bind the court to that. We're not going to object, but we can't bind the court to that.
All right. So Ms. Radke, again, what would you like to do today? Do you want to accept that offer or not?
Your Honor, I would be interested in accepting it only if there is a deferral offered. I personally think it would fit under the definition of corporal punishment myself. There's just a dispute with a 14-year-old.
offer that's been made to you, ma'am, is plead to domestic violence, dismiss child abuse in the third degree. The prosecutor doesn't have any objection to the court using 769.4A to dismiss the domestic violence case if you successfully complete the probationary term, but he's not attempting to bind the court to that. So your option is to say, okay, I'll either take that with that information still somewhat unsure of whether or not I, as the judge, am going to impose 769.4A, or to not do that. I'm not going to negotiate with you. That's not my job. So the offer is plead to domestic violence, let the judge decide whether or not there's going to be a deferral under 769.4A or not. That's your options. So you're either going to take it or you're not going to take it. I'm not going to negotiate with you.
Understood, Your Honor. I will take it.
All right. If you want to do that, take advantage of that offer. You'd be giving up your right to have a trial and all of the rights that would happen at a trial. Do you understand that?
Yes, Your Honor.
All right. I'm going to explain those trial rights to you so that you can make an informed decision. At a trial, you'd have the right to see, hear, and question. Excuse me. At a trial, you'd have the right to have a trial in front of a judge or a jury. You'd have the right to represent yourself at a trial or to have an attorney represent you at that trial. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence and to get a subpoena to require witnesses to appear and testify. At a trial, you could testify, or you could remain silent and not have that silence used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
I do not.
All right. Understanding all of that, do you still wish to enter your plea as this agreement, as to this agreement?
Yeah. Yes, sir.
All right. Did you raise your right hand so I can take some testimony from you? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, go ahead and put your hand down, ma'am.
Yes.
Other than this plea agreement, has anybody promised you anything in order to get you to enter this plea?
No, sir.
Has anybody threatened you in any way to get you to enter this plea?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
The domestic violence charge against you then would read as follows. It would say that on or about March the 16th of 2026 in Livingston Township of Otsego County, that you did assault and batter Riley Soraya Tingley, a resident or former resident of your household. Is that true?
No.
All right.
But I would prefer the.
You would prefer what, ma'am?
I would prefer to just take the deal.
Well, I can't take a plea from you unless you're going to admit that you did something wrong. If you don't believe that you did something wrong, then I can't
yes,
take a plea from you.
Yes, sir. No, Your Honor, I'm sorry. I misunderstood. I absolutely do admit that I did something wrong. But to this extent, no, it was not. But I did do something wrong.
Well, that something has to amount to domestic violence, which reads that you had to assault and batter Riley Soraya Tingley, a resident or former resident of your household. Is that what you did?
Yes, Your Honor.
What is it that you did that was an assault or an assault and battery upon Riley Tingley?
In summary, Your Honor, I was a bit on high alert because of my son's situation surrounding what is going on with him at his school. And I was trying to speak with Riley and letting her know that we were going to leave on Tuesday morning. And she wasn't listening to me. So I had attempted to open hand slap her, but she blocked it. And the police reports or the report says that I left red marks, but I didn't even make contact with anything but just the side of her arm.
All right. Ms. Radke,
Yes, sir.
Hang on a second. The legal definition of assault or assault and battery is an act which either is a battery, that is a physical application of force against someone else against their will, or it is an attempt to do a battery, which is the physical application of force against someone else against their will. Did you do that in the open-handed slap attempt that you've described to me? That is, you tried to hit her against her will.
Yes, sure.
The domestic violence and assault statute also says that parental discipline, reasonable parental discipline, is not an assault. Are you telling me that you did not do reasonable parental discipline?
Your Honor, due to the circumstances, I absolutely believe it was reasonable because I was trying to keep my children in a safe place. So ironically, this is where I'm at now. She didn't want to move because of her friends, and I understand that.
And I was not there, ma'am, so I can't say myself what you did or what you didn't do or what the purposes of that was. But the effect of telling me that you were doing reasonable parental discipline is a defense. And if you're going to enter a plea, I can't have you I can't have you saying that you entered a proper defense. You have to tell me that what you did was in fact wrong. If you're doing reasonable parental discipline, that is not a wrongful act. So your decision is, do you want to tell me that it was not reasonable parental discipline, or do you wish to assert that as a defense and have me set this for a further hearing in the future?
Your Honor, may I have a little bit more time to see if I qualify for an attorney? I have not had any luck having one get back to me.
I think that would be a great idea.
Thank
So
you.
I am going to adjourn today's hearing.
I appreciate it.
Today is the 2nd. Would 2 weeks be sufficient, or do you need 3 weeks?
3 would be ideal, Your Honor.
4:23 in the afternoon. Yep. April the 23rd at 1:30 for a Zoom hearing. It'll be start out just like this one was. So we'll adjourn this matter to 4:23 at 1:30. Please do not wait until the last minute, because your attorney is going to need to be up to speed so that we can take some action at that hearing on the 23rd. So please take every reasonable attempt to get that attorney as soon as possible. So we will adjourn today's hearing. Until then, do you have any other questions for me, ma'am?
So the one, I believe there's another hearing scheduled on the 9th that has now been replaced with.
Yeah, that's called a preliminary examination. That's on the more serious child abuse charge because it's a felony offense. You have the right to have that hearing, and that is a hearing where the prosecutor brings in witnesses. and a small amount of evidence called probable cause to show that there's some evidence called probable cause that you committed the crime of child abuse. Typically, that is done if there's not going to be an agreement between the parties as to a plea. You have the right to do that hearing, but you also have the right to postpone it so that you can talk with an attorney and find out what your best options are. Do you want to postpone that hearing to let you talk to an attorney and see what your best options are?
That opportunity would be ideal, Your Honor. Thank you very much.
All right. So I'm going to, what we typically call that is a waiver of the 21-day rule. That simply says that you have the right to have that hearing, but you want to postpone it to give yourself a little bit more time to investigate or to talk with an attorney or to reach an agreement with the prosecutor. And that's a fairly normal process. So I will find that you have properly waived the 21-day rule today, and that will give you a little bit of additional time. We will cancel the preliminary examination on April the 9th, and we will set a new hearing on the 23rd as a status review, much like today's was, to see what, if anything, that you want to do and whether or not your attorney is ready to assist you at that time. Any other questions that you have, ma'am?
No, Your Honor. Thank you.
All right. That's all for today. Good luck getting an attorney, and I'll see you on the 23rd.
Thank you very much.